Good afternoon, everyone, and welcome to Butzel Long's webinar, RIFs, Rightsizing, and Cost Saving during the Coronavirus Crisis. During this afternoon's presentation, please feel free to submit questions to the presenters using the GoToWebinar questions panel. Our presenters will answer as many questions as they can at the end of the webinar, time permitting. Also, a copy of this presentation will be made available this afternoon on the Butzel.com webinar event page. With that housekeeping out of the way, I would like to introduce Butzel Long shareholders, Brett Miller and Bernie Foos. Bernie?
Thanks, Jonathan. Much appreciated. And welcome to everybody attending on the webinar. A few things that I just kind of want to get out of the way right at the outset is number one, like most of you, myself and Brett are working from home. This is the new normal. So if you hear a screaming kid or any kind of crying, my apologies ahead of time. I have full 4 children under 10. Brett has 2 under 10. So much like you all, we are doing our best working in the new normal. But again, if we have a inadvertent co-presenter coming in and screaming, just bear with us, give us a smile, and cut us a little bit of slack. Number 2, obviously the title of this is RIFs, Rightsizing, and Cost Savings. And I can tell you, Brett and I have redone this presentation about 3 times in the last 3 days, and certainly in the last 24 hours. We're going to get into what you can do as employers and businesses as you're navigating these uncharted waters, dealing with the coronavirus and everything that's coming at you right now. Before we kind of get into that, there's a lot of moving parts. What we really wanted to touch on was, for Michigan purposes, Governor Gretchen Whitmer issued an executive order yesterday, as most of you probably know. It's a stay home, stay safe executive order, and good intentions behind it. Of course, everybody's trying to stay safe and protect the public and do the right things, but it has definitely caused a lot more confusion, frustration, and angst among certainly our clients and pretty much every kind of business out there, separate from just the individuals who are concerned. So if you're out there right now in your capacity as an employer or a business, or even just your individual capacity, and you're feeling frustrated and you're feeling scared and you just have this uncertainty, what I can tell you is you are not alone. Pretty much everybody is in this situation. So if you're freaking out, if you're concerned, just do your best to relax. Know that a lot of companies and a lot of people are in the same situation, and we're all trying to navigate this as quickly as possible. And that really kind of brings me to my last point before we jump into it, is everything I and Brett tell you today could change in an hour. Okay, you got to have your contingency plans kind of ready to go and ready to execute, but everything's changing right now. The government, the state, the Fed, everything's changing by the minute. I've got my TV on behind me. We'll talk about some of the other federal legislation that may be enacted and how that can affect all of these potential decisions we're talking about today. But just do your best to relax, stay calm, and we'll try to help guide you through all of this. So let's kind of get into it right now. We're going to talk about the stay-at-home order like I talked about. We're going to talk about ways to reduce the costs, maybe without having to do RIFs, potential federal aid. That's right now what Congress is looking at. I've read 400 pages of the Senate bill. I've read 1,400 pages of the proposed House bill. Politics aside, we don't know what's going to happen, right? But we are monitoring that. If you happen to exercise and decide to do RIFs, what are the risks to that? How do you actually implement a RIF if you want to go down that road? And then if we have enough time, certainly if all of us and businesses are to come out of this, you have trade secrets, you have confidential information. How do you handle those in these kind of crazy circumstances? So let's talk about Governor Whitmer's order. Again, it's the stay at home, stay safe order. And she's essentially temporarily requiring everybody to suspend activities that are not necessary to sustain or protect life. This is going on in multiple states right now. Michigan is one of, I think, 14 or 15 who have now issued these kind of orders. The whole goal, again, is to protect life, to make sure we're all staying safe, we're not infecting each other, and to really kind of flatten the curve, as they're saying. But Michigan, like other states, there are a bunch of exemptions to the stay-at-home order, and that's where our clients are having a lot of difficulty trying to navigate those waters. It's supposed to deal specifically with critical infrastructure workers, and then there's exemptions with that. I'll get into the order in more detail right now, but this order as of right now is staying in place until April 13th, 2020. Whether it gets extended, who knows? But all we can do is monitor it day by day, frankly, hour by hour. Now, I looked at this, and really there's three buckets you want to focus on with this executive order. You've got, on one bucket, you've got exempt companies, and we'll get into that. On the other second bucket, you've got non-exempt companies who don't fall under any of the exemptions. And then the third bucket is the guidance to everybody, whether you're exempt or not exempt, on what you're supposed to do. So let's start with the potential exempt companies and businesses. So number one, businesses and operations that employ critical infrastructure workers. Sounds good, sounds simple. It's not. I'll get that into the next slide. But there's a whole list of categories, transportation, healthcare, you name it, that qualify as critical industries and services, and thereby critical infrastructure workers. Just to proactively address this, folks, at the end of this, Brett and I are obviously going to take questions. We're probably not going to be able to answer every individual question, which would likely be, am I exempt? That's usually for an offline discussion. It depends on the industry. It depends on your business. It depends on what you're doing. The purpose of this webinar is to kind of give you a quick overview. But if you have these very detailed questions like that, we'll be able to address that offline. So again, number one, of your exempt company, you would be providing critical infrastructure services, things like that. Well, what do you do if you find that you are an exempt business? Okay, you don't get a license or a certificate from the government saying you are exempt. What we have right now is an order from the governor. You effectively have to self-designate. If you think you fall in to one of those exemptions, you self-designate yourself as a company. Certainly offline, our executive order team can help guide you through that process. But again, to the extent you're looking to get a blessing from Governor Whitmer or any state agency to confirm that you are an exempt company, that's just not happening right now. It's really on the honor system. You have to look at it in conjunction with your attorneys and make the best business decision possible, whether you actually are an exempt company. If you self-determine that you are an exempt company, what do you do then? At that point, a couple things. And I got number two here. You should designate and send letters to your critical workers. So again, what you're limited to do, even if you're exempt, is the critical work. So if you're a construction company providing services, fixing essential roads, bridges, things like that, you need to designate and send letters to the workers who are going to be working on that very specific project. Now, you may be in a business that provides essential services and maybe non-essential services. You have to focus on the essential service and what is needed to do those essential services. And you have to have critical workers. So the first thing you need to do is designate and send letters to the critical workers. In the last 24 hours, we have been advising clients, helping them draft these kind of letters. Obviously, each industry, each business, but usually the letters say something to the effect of, we have designated ourselves as an exempt company to provide these exempt services. We designate you as an employee or worker to do these critical services. And here's a letter allowing you to do that work in case you get pulled over by the police. These letters that you give to the employees, you want to do it quickly. You want to get it into their hands or at least email it to them so they can print it wherever they are, such that if they're going out to sites and they're driving around, if they happen to get pulled over by a police officer, they at least have this letter to show them they've been designated as a critical worker. Now, we've been monitoring this last night into this morning. The message from the police and the sheriffs are, don't worry, we're not going around pulling people over. But then I just got a call from a client about an hour ago. They did get pulled over and they had to show the letter. So in an abundance of caution, and it's got to be done quickly, you should at least get letters out to your critical workers. Number three, if you determine that you're an exempt business and you've got suppliers or distribution centers, you need to designate them and send them immediate letters or emails designating them as suppliers and distribution centers. We've already caught wind that, some of the OEMs like GM have already sent out letters to their suppliers saying that they're critical and they need them to continue to supply and distribute. And separate from the auto industry, there's a whole bunch of other industries that we'll get into wherein they will be deemed suppliers and distribution centers. Some of you on this call may not be an exempt business by yourself, but you may receive a letter from one saying they are, and they're asking you to continue to supply and distribute. And that brings us to number four. If you are designated or receive a letter that you are a supplier or distribution center, basically rinse and repeat. At that point in time, again, you're not going to get a certificate or a license that says you're authorized to work. If you get a letter from someone like a GM or someone else who determines that they are an exempt business and they need you to supply, I think you probably have a good faith basis to go forward and provide your supplier and distribution of what you need to do. And at that point in time, you'll then likely be able to designate your suppliers and distribution centers to fulfill those critical needs. Candidly, guys, it is nuanced, it's a little complicated, and a lot of these discussions are offline and it's business specific. But right now, just if the only thing you take from this, you're not going to get a certificate or a license from the state. You're going to have to self-designate and do your best to navigate these waters. You're not going to get a clean bill of health from any attorney or anybody else. They can't do that. You got to analyze this, the order. You got to analyze the business. And typically what we're advising clients is to kind of err on the side of good faith of what you think is critical and supply. So that's for the exempt companies. And again, there's more to that, of course. Critical infrastructure. Again, this is part of the order. These are the kind of sectors the governor has designated to be what she calls critical infrastructure. Healthcare and public health, hospitals, obviously, law enforcement, food and agriculture, energy, water, transportation and logistics. And it appears that GM and other OEMs are determining that all of their stuff, for all intents and purposes, is critical. Public works, the news media, manufacturing, and we got a lot of clients who are kind of in that limbo stage. They're not really manufacturing something that's protecting life, but they are manufacturing parts for other people that are. So they're kind of caught in that limbo stage. Financial services, legal services, and obviously other kind of supply chains, and certainly those that are supplying some kind of services or products to the defense. Other exempted businesses, child care workers are exempt. Again, suppliers and distribution centers, people in the insurance industry to the extent they can't do it remotely, workers and volunteers for food, shelter, things like that, obviously grocery stores and the like. Workers who perform critical labor union functions, things like that are exempt. Now, the second bucket are the non-exempt companies. So let's say you just run a fitness studio or something that isn't exactly falling clearly under the exempt criteria. You actually may still designate certain basic operations and have people go on site. So again, things that you need to conduct the minimum operation. So a lot of businesses, even the workout facilities, people like that, they're doing things online, they're working remotely. So long as you can kind of continue to do that business with people working remote, you can continue. If you need people on site, we call it the basic operations, people valuing the inventory and the equipment, caring for animals, ensuring security, processing transactions like your AR functions with payroll and benefits, anything that facilitates the abilities of the rest of the team to work remotely, your IT people, your HR folks, your accounting folks. I think the best description we can give is you're still allowed to at least have a bare bones skeletal crew going out there. Like us as a law firm, like myself, the lawyers, our board, you name it, we're all working from home, including our assistants. That said, our IT people can go into the building and leave to go into the building to make sure the servers are working such that we can continue to work remotely. Same thing with HR and accounting. Even the law firms like us are adapting. Third bucket, whether you're exempt or you're not exempt, no matter what, all companies have to comply with these 6 things. Number 1, you still have to adapt social distancing measures and other mitigation measures. 2, that could, again, restricting the number of workers to perform the necessary tasks. So if you're a construction company going out and you only need 10 people to do the project for today, you don't need to bring the rest of the 20 people with you. The only numbers that you need. Number 3, again, to the extent possible, promote working from home. So again, if it's critical and absolutely necessary for this person to be on site, fine. But if they can do it remotely, encourage and promote that. Number 4, no matter what, try to have your employees or workers be at least 6 feet apart. Some companies, that's easy to do. Some companies, like construction companies, that's a little bit more difficult. And you kind of get into that gray area. You got 2 people working together, helping to lift something, and they're not 6 feet apart. How do you balance complying with the order versus getting in trouble? And actually doing an effective job. Number 5, no matter what, increase facility cleaning and disinfection. So if you do have even skeletal crews going into the building, you should be sending cleaning crews in there to do deeper cleans, disinfect, to make sure you're protecting those employees and workers that are kind of going into harm's way. And then the number 6, the catch-all, is anything else recommended by the CDC. You see a lot of companies just saying that. This next slide is for those of you who love flowcharts and yes and no boxes. We kind of put this together for you. I'm not going to get into it in too much detail. You can certainly get a copy of this presentation after we're done in 40 minutes or so. What we've done at Butzel Long, and other firms may do it as well, but after Governor Whitmer issued that order yesterday, given the so many questions and so many concerns about what is complying, what isn't, what are the penalties, we decided to put together a quick executive order analysis team. So again, we might not be able to answer your question on this webinar specifically because we only have so much time, but what we've been doing is if somebody has a question, somebody has a concern about how this order affects their business, we've been scheduling calls every 15 minutes with clients and potential clients, getting our team on the call, walking through your business, walking through what you can do, walking through these letters. We've found that, yeah, these webinars and our client alerts are going to be helpful, but sometimes you just need someone on the phone kind of helping you talk and walk through it. So on an emergency basis, we put together this team yesterday. We're around today and forever long as needed to answer questions offline, to schedule calls, and to kind of walk and talk you through what we think you can do and put you in the best position possible to make the best business decision. So if you guys have separate questions offline after the webinar, you can reach out to Brett or myself or anybody on this executive order analysis team, and we'll try to schedule a call. So again, there's a lot more to the order, folks. I know we can't get through it all. We're trying to keep it at a high level as much as we can right now. But again, if you're a business right now and you have to temporarily close, this throws the wrench into RIFs, right sizing, and cost saving. That's what Brett and I were going to talk about today, and I'm going to pass it on to Brett right now. What can you do to kind of save the business, to manage your workforce? But again, this whole executive order really throws a wrench into it and may expedite some of the decisions you have to make. So Brett, why don't you kind of take it from here from an employment perspective?
Yeah, thanks, Bernie. There's a couple things going on here, right? I mean, a lot of clients are calling their brokers to figure out, uh, is there some kind of insurance available? Is there a business continuity insurance that we can utilize to kind of bridge the gap, cover some of these expenses, the downtime? And it's pretty rare, but it's worth contacting your broker if you haven't already. Call your insurance broker, figure out if you've got that insurance. Bernie, I know you are a glutton for punishment. You said you've read all the pages of these bills that are proposed but still out there. So, I mean, I'll ask you on this one since you've gone through it. What do you think businesses need to know right now about at least the potential federal aid?
So on the federal side, in the Senate, there was a 400-page bill. They're still negotiating it as we speak. I just got done watching Chuck Schumer speak on the floor right now. The gist of it is about $500 billion in loans and grants for all kinds of businesses to make payroll and to subsidize them. Another $350 billion for what they call small businesses or mid-sized businesses to address payroll costs, payroll expenses. The idea behind that, at least the discussion, was anybody who's about 500 employees or under could be eligible to meet the small business requirements or the mid-sized business requirements and potentially get loans to cover their payroll for 5 or 6 weeks for anybody making under $100,000. Now, there's a whole bunch of debate and back and forth about whether these loans would be forgiven, such that it's essentially a grant or free money, or whether the government would take some kind of interest in the business and put all these requirements if you do take the money. That just hasn't been ironed out right now. Those kind of big ticket numbers, though, 500 million, billion, 350 billion, I think those are real numbers on both sides, both with the Senate and the House. And certainly if those become available, the idea on both sides is to make this money available in days, not weeks, meaning employers across the spectrum, suppliers, professional services firms, you name it, can actually get the loans, cover the payroll, keep these people employed for a couple of months, as opposed to kicking them off and letting them go to the unemployment line collecting unemployment insurance. The idea behind this on both sides is to really keep people employed for the 5 or 6 weeks. So when it's restarted, if and when it's restarted, everybody can kind of pick up where they left off. Again, Congress is Congress. I hated politics before and I hate it now. And I've read both the Senate and the House. We don't know what's going to happen. Everything I'm talking about right now could change in 15 minutes. The big thing is we just got to monitor it. We're on top of it. When that legislation is passed, and I think something will be passed, that may change your decisions that Brett's going to get into right now. If you're considering RIFs, if you're considering furloughs, freeing up this money and having access to this money may change that decision. But right now, I think you need to talk about, if it doesn't happen, what do you do? And Brett's going to get into that. But if this money comes into play, we're monitoring it, it may change the game for you. Same thing within the state of Michigan. We actually put out an alert this morning. My colleagues, Robert Schwartz, Jonathan Kirkland, and Steve Etherly put it out. There's about $20 million that could potentially be available for smaller businesses that are negatively impacted by the program. These funds are to be available no later than April 1st, so next week. So if you are a super small business, we can kind of guide you through that, but you could apply for those small business loans and or grants. For companies that are under 50s, they're talking about this aid in terms of grants. With companies 100 employees and under, they're talking about these being loans. So if you think you might qualify, we did a whole big client alert. You can check it out on butzel.com or email us separately. We can kind of get you the details and you might be able to apply and get some relief on that end. So long story short, just monitor the legislation. If money becomes available, dive in and try to get it. And that may negate some of the tougher decisions Brett's going to go over right now.
Yeah, Bernie, we've got, again, changing this up on the fly. We had a analysis of cost reductions that businesses and companies can do without having to actually lay off their workforce. Now with the executive order, we'll kind of break this into two conversations. Those who are not critical businesses or not essential and are having to sort of slam on the brakes and consider what to do with their workforce on the fly with the stay-at-home order. We'll talk about that. But there are other companies that are doing business. They may be critical, or if determined they're critical or they're essential, they can stay open. But business is limited or business is down and they have to figure out how they can reduce costs and bridge this gap until we have some more certainty from the government, either on the loans you discussed or the stimulus package. But from what we can control right now, what are clients able to do, or what are these companies and businesses able to do? So there's a couple options that we can go over in terms of reduction in hours. There's unemployment programs. We talked a little bit about aid. There's options to cut pay, furloughs, or other programs that are available that don't relate to having to work, lay off your entire workforce. I think the most common that we get is, okay, can I just cut hours? This is your non-exempt hourly employee staff. Let's eliminate overtime if there's still business to have overtime. Can we just cut down hours of the hourly staff to save our payroll costs? For those employers that don't have a union, this is a very simple process. You just figure out what costs you need to save, reduce the staff hours to 50%, whatever it may be, and you only pay those employees what they work. So for non-exempt employees, that's an easier decision. If you have a union, you got to consult your collective bargaining agreement. Sometimes, when you're talking about shift reductions or effects of this kind of decision, it may have to be collectively bargained with that union. So something to consider. For unemployment for these individuals, even if they're underemployed, due to an hour cut, if they qualify, they can still get unemployment. If they've been completely laid off, they'll seek unemployment. The governor did issue an executive order that indicated that if this unemployment is necessitated by one of these executive orders, by the business shutdowns, it's not supposed to count against the employer experience rating. In other words, it's not supposed to penalize the employer by paying higher taxes because they're forced to be closed. We'll see how all that shakes out, but right now that's part of the executive order we've listed on the slide to give employers some comfort, and employees who may be having hours reduced or furloughed, temporary break, can go get unemployment. Michigan's also expanded its work share program. This is a program for employers who are essentially reducing the hours of the staff, as we talked about. If you're cutting those hours, what happens is unemployment can pick up part of it by paying unemployment for the period of time that the employee's hours have been cut. Then the employer, of course, pays them for the hours they work. So in theory, the employee gets a little bit of a benefit in terms of getting unemployment benefits to make up for the lost hours. The employer gets to keep them on payroll, maintain benefits, not lose staff. There are some requirements. You can only have cut hours between 15 to 45%. This isn't going to be forever, but this is a temporary measure from the government. So there's some things you'd want to look at if work share is an option, but it is something that a lot of employers are considering. There's certainly some eligibility requirements. Everybody has to be kind of up to date on their taxes. You're talking about using this for the current full-time employees, and there's certainly going to be some probably new rules coming out on this, but you're going to have people who are otherwise eligible for the unemployment to participate. Another measure for companies who are keeping employees on, looking at their critical infrastructure and the work, we're seeing a lot of confusion about, okay, we have the business open, we're maintaining this critical infrastructure, but now we're having trouble even getting employees to come to work because they are afraid or they have things going on at home. On top of that, Congress passed the Families First Coronavirus Response Act that expanded the Family Medical Leave Act to cover COVID-19 related issues. And it also put in place an Emergency Paid Sick Leave Act that would provide up to 2 weeks of paid sick leave for things like businesses closed due to an isolation order, or having to care for kids who are home for a school closure, which puts a pretty big chunk of Michigan employees automatically eligible. This law takes effect April 2nd. It applies to businesses with less than 500 employees, and public agencies as well are covered no matter how many employees they have. But the larger employers are exempted. They're presumed to have kind of paid sick leave already. But so if you have under 500 employees, it applies to you. And even the expanded FMLA, the normal FMLA rule is 50 employees or more within a certain area. And this is going to apply to even those with under 50 employees. So kind of a huge change on the fly employers are going to have to get used to. We're having a webinar on that tomorrow morning at 9 a.m. where I'll be speaking on kind of all the details of how this is going to work, the open questions, things that employers really need to consider. But it's going to come into play because if companies are considering layoffs right now, reductions in force, starting April 2nd, there's going to be a new leave entitlement that requires employees to be paid for a lot of reasons that already qualify. Now, the benefit to employers, supposedly, is an available tax credit to repay employers for the paid leave, whether it's under the expanded family medical leave or the emergency paid provision. The theory being that the payroll taxes will be offset so that there's a dollar for dollar balance for employers to recoup these costs. So we have a couple details here that the government has released so far. Okay, there's an allegedly 100% reimbursement. It's supposed to include anything you pay for health insurance. It's supposed to be fast. Then again, we're also talking about the IRS. So there's a lot of uncertainty around this. And our group with O'Keefe will be putting on a webinar tomorrow afternoon as well, O'Keefe Accounting, to kind of walk through some of the actual tax and business cost aspects of this. But we wanted to flag this for employers because the governor or the government has put out even an example of how these tax credits would look. The whole theory being, again, it's withholding from your payroll taxes on employees an amount to sort of offset whatever paid leave you have to pay. If you're a restaurant, this probably isn't going to help much. You're closed down. You don't have a lot of payroll taxes anyway for kind of tipped employees. For other employers who have a large payroll, or they're not worried about fronting paid time off and then having the government subsidize it, these kind of tax credits may be beneficial and may be a great way to help keep your workforce employed and on the books during this crisis. But again, we'll be talking more about that tomorrow. Regulations are not out. The government is supposed to put out a poster with more details on this law tomorrow. So again, the stuff, as you said, Bernie, is changing by the hour. We should know more, but there is at least an available, supposedly, availability to offset some of these costs. But employers are also considering other options. Some of these.
Hey, Brett, can I interrupt real quick? And I just want to ask you a question. This is a common question I'm getting, and I know you're getting, and it's a tough question. I think the answer is it's a business decision, but I want to ask you, right? I'm a business, whether small or mid-size. On one hand, I'm being directed to provide critical services, whether they are critical services or I'm a supplier. So I want to stay in business. I want to do these things. I want to help. On the other hand, I've got employees who are understandably nervous. I could be arguably putting them in, regardless of whether it's critical or not, they're nervous to go to the site. They're nervous to go here. They're scared. They don't know what to do. I'm making them effectively, if I want to stay in business, go to do these jobs that they don't want to do. To me, from a business standpoint, if we ever get through this, and assuming we get through it, potential employment claims, insurance claims, disability claims, you name it, I feel like as a business, I would be exposing myself more so on putting my employees in a position where they're going into unsafe territory and the potential lawsuits I could get over the next year or two. How do you help someone or a business kind of thread that needle to making that decision? And that's not a fair question, but that's the question we're getting right now.
It's a great question, Bernie, and it is a common question. I think the answer on how you thread that needle is carefully. We've already seen one lawsuit filed against from a manager at the Detroit Zoo who was claiming he was forced to work around crowds in violation of what was then the crowd size executive order from the governor. That's brand new, but I mean, it just shows you that there are attorneys out there looking at this. There are potential legal risks and ramifications. The government has urged flexibility with your employees. The EEOC has urged flexibility with employees. That said, it's really a case-by-case basis. You know, when you have healthcare workers, for instance, who are refusing to do patient care out of sort of a, you know, just a general fear rather than having some kind of documented reason. That's a more clear-cut example than some of the other industries where you have people who are calling in saying they have a fever and they don't want to come to work, which a lot of employees will do, even if they, may not have a fever. They may just be kind of taking advantage of the system. After April 2nd, when these new rules come into play, we may have even more concern because there's a broad category of reasons that employees can take off work that's protected, frankly. One of them for paid medical leave is, displaying symptoms of COVID-19 and seeking medical treatment or seeking an assessment for it. With the health system right now, who knows how long that would take. Someone could call in and say they're having symptoms and they're entitled to paid leave after April 2nd. So there's a lot of moving parts to this. We're kind of taking calls from clients on a case-by-case basis and walking them through it. As of now, it's the biggest challenge is making sure that for the critical infrastructure, those who are still working, that you can keep employees there. And urging clients to maintain the CDC guidelines, reassure your employees that you are sanitizing, you're maintaining those guidelines, observing the social distancing within the workplace, anything you can do to make employees feel as comfortable as possible and that they want to come to work. Because Bernie, you're right, there's going to be potential issues of workers' comp if someone's exposed to the virus at work or gets it. There's going to be potential discrimination lawsuits, retaliation, whistleblower. I mean, we could certainly see some legal liability coming out of this. But at the same time, if you're critical infrastructure, you need to try to maintain your workforce. So it's a delicate balance. And it's one that's sort of weighed against, those who you need to have in the workforce. And as we're saying, those cases where employers are cutting back, businesses are trying to figure out, they may have critical people, but they can't keep all of them, or they can't maintain everyone on payroll at the current level. Bernie, that's where we're seeing some questions about salary reduction. We talked about cutting hours for your hourly staff, but when you're talking about exempt employees, those who are just paid on a salary, there's some special rules. You have to be a little careful. You could do across the board salary cut for those exempt employees. You got to be careful that if they do any work in a work week, they're supposed to be paid their whole salary. There's a few exceptions for that, but you usually want to do a salary reduction to be some kind of more permanent decision. So one of the examples the government gives is if you want to reduce your exempt salaried employees to a 4-day work week and then cut their salary to 80% salary, that's something that's been allowed. You can't reduce it below the applicable $684 per week minimum salary threshold that the government's put into place. But so within those confines, employers do have some ability to cut the salary. Another example or another option is simply furloughing employees. So, again, for the non-exempt hourly folks, you're not working, you don't get paid. As I mentioned, for the employees who you know are exempt or getting salary, you want to make sure that that furlough goes by the work week. The furloughs are, more of the sort of temporary shutdown, or a kind of repeat. Once a month everyone's gonna take a week off of work. We're gonna shut down for a week. That's your kind of classic example. A lot of companies want to maintain health benefits, right? So during the furlough, you're gonna have employees on health benefits, but you need to contact your insurance carrier. A lot of different companies, a lot of different third-party administrators have different rules within your own plan documents about how you pay benefits for furloughed employees. So something to consider there.
Right, can you kind of just quickly explain the difference between a furlough and a layoff? And a common question we're getting is, if I do decide to do a furlough, how long can I do it for?
Sure, furlough is again designed to be temporary, whereas and people call it different things. It's really, sometimes your benefit plans define them, use different words, but when you're talking a furlough, you're talking a quote unquote temporary layoff, a temporary leave, whatever you want to call it. It's typically designed to be in a fairly short duration. The point being that there's an expectation that everyone's going to come back to work at some point. You're going to maintain those health benefits generally during the time but you're not paying payroll. You're stopping work for that period, and then you bring everybody back, as opposed to a layoff, which is a more permanent reduction in force. You're terminating people's employment. You're not paying their benefits. They can take COBRA, but you've shrunk your workforce, and there's no expectation of calling them back. That's sort of, right now, a lot of clients are more in the temporary realm, right? We're all hoping that this bounces back quickly. People can come back to work. The questions are really, how long can we go? And furloughs, to your question, I mean, they can go up to a year. We'll talk a minute about the WARN Act. It gets a little dangerous if you're fall under the WARN Act and you're going up to 6 months. But really, a lot of times your benefit plans will govern that length of time, because some insurance will allow you to keep people off work as long as you expect to call them back, for as long as you're paying premiums, or for several months. Others are a little more strict, so you want to contact your broker to get those details to really determine that end date for your furlough.
I'll jump in real quick, and just for everybody on the call, we're approaching 12:45. We're scheduled to go to 1. Brett and I are going to continue to go as long as we need to answer questions, and there's some more slides just given the activity. So if anybody's freaked out that this is going to end at 1, don't worry, we're willing to stay a little after and keep talking and answering questions. But go ahead, Brett.
Yeah, it's not like we have anywhere to go. I was mentioning furloughs, Bernie, for your exempt staff. One thing that's really, I think, critical is that you have to have a no work rule for anybody who is a salaried employee. You're going to have them off on a full week increment, as I indicated. But again, if they do any work, if they check email, if they're logging in to your computer system remotely and doing some kind of project, you got to pay them for that week. So furloughs are supposed to be a complete no work during that time period. A question we're getting a lot, though, is, okay, I've got somebody who's not doing any work. We've got them off. They're exempt for the week. Do I have to pay them PTO or vacation? Unless you have something in your policies that somehow requires this in Michigan, you don't have to pay them. You can mandate that this is an unpaid week. And the Fair Labor Standards Act, again, for your exempt employees, allows you to not pay people as long as they're not performing any work in that work week. So something to keep in mind. There's other options to keep people or to kind of reduce the workforce without a full-blown reduction in force. Right now, most clients aren't thinking of early retirement or voluntary separation programs. A lot of these require, some kind of severance payment, which most companies aren't trying to shell out cash right now, but it is something to keep in mind. On the other hand, we have reductions in force, right? And we have a very large swath of the Michigan economy that has had to shut down and is putting on the brakes of its workforce right now. We're getting questions in terms of, we have to shut down, so our business needs are really nil. We're not shipping products but can we afford to keep our people on payroll for some period of time? Can we afford to pay benefits? Or do we need to consider, a full-blown reduction in force? And at that point, one of the first things you need to do is determine what your workforce is going to look like afterwards. Do you need 80% of your staff? Do you need 90%? Are there critical people? But when you're considering all of what we're dealing with right now, in terms of the costs and where you want to be in, say, 6 months, that's one of the key questions: is what is your workforce really going to look like? There's legal risks when you are planning the reduction in force, when you're trying to figure out that workforce composition. And I spent several years after the last recession, litigating lawsuits, defending companies who were sued for the way that reductions in force were handled. This year this time it's very different because we have a government ordered shutdown for a lot of businesses. But for those who are considering having to lay off certain portions of their workforce and keep others on in the critical, in kind of that critical infrastructure employment, you got to think about who is going, who is staying. Are you treating people, the same across the board? Or are you just sort of picking people you don't like, or, with no real business justification? There's also something called a disparate impact claim in a reduction in force. So, some companies used to say, we're going to pick the highest salary earners and lay them off. Well, in most companies, the highest salary earners were the longest tenured employees, the older employees, and then it would, 99% of the people who were laid off were in a protected age category. And guess what? They got a lawsuit. Even if they didn't mean to discriminate, the effect of that decision led to some potential liability. If you're talking about reductions in force also, and who's going and who's staying, there's usually a duty to bargain with unions if you're a union shop, at least on the effects of a layoff. So we're also getting clients getting information requests from unions that are, if you have a union, you have to legally respond. A lot of clients also don't realize when they're talking about cutting costs, salary reduction, or layoffs, that it has some pretty severe potential immigration issues. If you have employees who are employed on a visa, and particularly H-1B visas, there's a problem with just cutting their salary because you filed paperwork with the federal government getting a certain prevailing wage determination and salary. And there's a requirement that you have to, really seek to change that, which I'm hearing is a 3-week time frame right now. If you're laying people off depending on their immigration status, they could lose the status. So we have an immigration team who's been fielding these questions. If you have anything specific, please let us know, because this is something that clients are looking to do, sort of these across the board decisions of reducing salary or layoffs, and the immigration issue can be a thorny one. I mentioned WARN Act. This is really an act that requires you to provide 60 days notice of a mass layoff or these particularly covered plant closings. There's a lot of rules that go into this, but typically what you see is if they're on a layoff of less than 6 months, you're not really required to provide the WARN Act notice. Where we get into a lot of litigation is when a layoff or a furlough or some kind of temporary layoff of work goes longer than 6 months. And when were you supposed to provide the notice? What do you have to do? If you have any questions about this, if you think you have WARN Act issues, we've been consulting on this. We can provide information on that as well. One of the key things in terms of actually designing your reduction in force, whether it's cost saving measures or whether you're laying people off, you need to first identify that business justification for whatever it is you're doing. And we recommend clients come up with what we call a RIF plan. It could be a temporary leave plan, it could be a cost cutting plan, whatever you want to call it. The point is, to identify what your business need is and what you're doing. And we have, some examples of that up here, and obviously COVID-19 is going to be the main one for everyone. But when you're looking at that need to cut costs, the plan should set forth some objective criteria. Okay, how are we picking whoever is going to have their salary reduced, whoever's going to be laid off, whoever's going to be furloughed? Is it going to be by, the most junior people in the department are the ones who are picked? Have you identified sort of a need for certain staff? We don't need our part-time employees anymore. We don't need our temps. Maybe those are people that you can decide that you don't need. Other companies look at disciplinary records. It's anyone who's on a performance improvement plan is subject to this potential reduction in force. Objective performance measures, the lowest sales figure people are the ones who are eligible for this program. Some companies use their last performance evaluation. Okay, anybody who had an unsatisfactory or below or some specific ranking might be included in a RIF. A lot of companies are designating specific skills that are kind of exempted from any RIF, so that's something you want to identify. Hey, we have critical engineers working on this project. We know we're going to get back up and running. We need those skills. We can't lay those people off. Okay, set forth why that is in your plan, and you can then work your plan around that. So these help you prevent those lawsuits and that liability down the line when you have objective criteria for why you're having to reduce the workforce. And you also want to review that plan. This is best done with counsel, so we maintain attorney and client privilege. We go through the disparate impact, as I gave an example earlier. Some companies want to give severance and release so they can waive potential liability in exchange for some amount of consideration. Right now, Bernie, as we said, that's not an option for a lot of people who are having to slam on the brakes of their entire business. But there's also some other factors that are going on here. We have people working from home or being laid off, and they have access to company property, company computer, and there's trade secret components to this as well. What are you telling clients about that, Bernie?
Yeah, it's honestly, these are unprecedented circumstances, but generally the same kind of advice that I would give in normal times apply here. Most of these employees, if you're going to do a RIF or a furlough or a full-blown layoff, most of them have confidentiality agreements, or they should. So whether you're going to be exercising this option over the phone, via email, things like that, you should, generally speaking, send reminder obligations to the people who are leaving. Say, hey, obviously we're letting you go, but here's a reminder of your post-employment obligations, which includes that you don't use or disclose company information, confidential information, and trade secrets. And two, if you have any company property, to return that property. That kind of letter should still go out, so you're affirmatively protecting your information. Within that same letter, again, if people have paper files, they should gather those things up and prepare them to return. If you have internet access and security issues like Duo and things like that, that kind of access should be shut off immediately. Most folks who are working from home, they have access to a server, or they have access. You should work with your IT department to make sure you snap your finger, hit that button such that their access is blocked off. And some technology allows you to actually wipe their phones or computers with the company information on there as well. Same thing with access to cloud or third-party storage, things like that. Now, practically speaking, if folks have hard copies in their possession, or they've got hard drives or thumb drives or any kind of drives, Dropbox, it's going to be a little bit difficult right now to physically go and actually take possession of those devices and that information. So what I would normally say is, in your letter, organize, prepare those things, and we will, set someone up to come pick it up when the current order is dissolved and or a new order allows us to physically go there and pick up the information. That's more of a logistical issue right now because of the stay-at-home order, but I think you can at least properly preserve that in your reminder obligation. Again, practically speaking, it might be difficult to pick up the stuff, but what you have to do is send out that letter, cut the access off as much as you can from an IT standpoint, and monitor those things if and when things turn around. So that really kind of is the end of our presentation right now. Obviously, there's a lot more detail, a lot more information that we can dive into and get into. You can reach out to our executive order team. You can reach out to Brett or myself individually offline and really get into those nitty-gritty details as needed. But right now, Jonathan and Brett, let's see if we can take a few questions.
Yeah, Bernie, we've got a few questions coming in. One for you. On the critical employees, let's say there's a company that is having to shut down. Question is, do we need a letter for our non-exempt, hourly employees to send somebody into the office to conduct the minimum basic operations?
The answer is yes. If you've got, right now what we're doing is we've got 2 draft letters going. We've got exempt companies and we've got, the skeleton people, the basic operations people. So if you got someone in IT who has to go to the office, I would send them a letter. Again, we've got a draft of what we're typically using right now, but it says something to the effect of you've been designated as a basic operations person that's critical to maintaining the remote systems, and you are hereby designated to go into the office and do what you have to do. So the quickest answer to that is yes, you do need a letter. Yes, you should get it into the hands of those people in those basic operations positions, such that if they get pulled over on the highway or they get the sheriff comes to the actual place of business and says, what are you doing? They at least have that letter from the company that says they're basic operations personnel.
We had another question, Bernie, that I'll handle was, wouldn't a reduction in hours go against benefit provisions in some cases, such as qualifying for healthcare coverage? And really, I think this goes to, under most provisions in the Affordable Care Act, health benefits are offered to full-time employees is defined as over 30 hours a week. So if you're cutting their hours to under that number, are you having to cut out their health insurance? And the answer is not always, and not really. There's a look back measurement that companies use to determine whether someone is meeting the full-time hours. That does so it doesn't automatically disqualify someone who's sort of temporarily had their hours cut. There's also a lot of flexibility built into these policies that sort of, as long as you are considering them full-time, paying the premiums, it's most likely not going to be a problem. But with specific questions, and if you're cutting hours for a fairly longer period of time, you're going to want to contact your benefits attorney and go through that plan document to really give you the best answer. But it's not one of these cases where if we cut somebody's hours down to 25 hours for a non-exempt employee, or for anybody for cutting hours down for 2 weeks, we have to suddenly cancel their health insurance. That's not usually the case. We had another question, Bernie, about unemployment. So if someone's only worked 3 weeks and they have to now be off work due to any of these situations, do they still get unemployment? The answer is they're probably not going to qualify for unemployment benefits through you or the company that just hired them, but they may very well still have unemployment benefits because the agency looks back at your prior jobs as well to make these qualification decisions. So it doesn't mean that they're necessarily out of luck. And I know a lot of companies are kind of worried about, I don't want to put somebody off work if they don't have any kind of unemployment availability. But as a practical matter, what we're seeing is right now, pretty much everybody's getting unemployment. I think we have a question about the new expanded Family Medical Leave Act. I mentioned the number of employees that would qualify for this act. And so the question is, if the employer has under 50 employees in a 75-mile radius, does this new expanded Family Medical Leave Act still apply? And yes, that definition is the standard definition for your normal Family Medical Leave Act. You have to have 50 or more employees within a 75-mile radius. The new law, for this specific COVID-19 expansion, applies to employers with under 50. Doesn't matter the radius, under 50. There's a caveat that if you have 25 or fewer, you don't necessarily have to guarantee job restoration, but the benefits are still going to apply, and there's the supposed ability to kind of recoup that and subsidize it from the government. And that's just the expanded Family Medical Leave. The Paid Medical Leave Act, which is again broader, also applies to all of those employers under 500. So this is going to be a big change for companies, smaller, mid-sized companies that aren't used to having to deal with some of these leave rules. We had a question that if employees are already out due to, I guess, everything that's going on before April 2nd, can employees still be eligible for the new rule when it rolls, these new paid leave provisions when they come into play in April 2nd? And the answer is that's one of the big unknowns that we'll be discussing in our webinar tomorrow. The way it looks right now, if it's a current employee is defined by the Fair Labor Standards Act, as of April 2nd, they would be subject to these leave provisions. Some companies who are making layoff decisions now, even though the law is due out, but it's not yet in effect. So some companies are making layoff decisions now and taking the position that as of April 2nd, this person's not an employee, I don't have to offer that paid leave. We'll be jumping into more details on that tomorrow, but it is a hot topic. We have one more we can go through here. A nonprofit that has an employee out on quarantine is full-time but not eligible to use his company leave time, although the law does not come into effect. Do we have an obligation to pay him now? So this kind of goes back, Bernie, to we were talking about your benefit policy or your employment policies earlier. Depending on what your handbook says about how you handle your PTO, and let's not forget about the Michigan Paid Medical Leave Act that went into effect earlier this year for available for sick time for Michigan employees or employers with 50 or more employees. That could be something that could come into play to require you to pay for leave for someone on quarantine. But the new law requirements don't apply yet. After April 2nd, that might trigger some pay obligations, but right now it's going to be kind of under your basic policies.
And again, we're getting a few more questions on these draft letters. And let me just take this time. Every business, every industry is different, but again, we're really advising clients that there's two potential letters you could be sending. One is for certainly exempt companies and employees. On the company letterhead, you would prepare a letter that basically says, the holder of this letter is an employee of the company. They are deemed to be a critical infrastructure worker as defined by the order, and that they're required to go to work in order to provide these services. We respect that you allow this person to continue it. You got to get this in their hands. Second letter is what Brett just talked about and asked me about was, can they maintain the operations people? It would speak in those same terms. And at this point, I would just encourage those who need help drafting those kind of letters or anything related to it about your business. You can reach out to me or Brett. My email is fuhs, F-U-H-S, @butzel.com. Brett, is it Miller, BR, @butzel.com?
Yeah, that's right.
There's the emails right there. That might be the easiest, folks, is just email us separately with the business. We can run a quick conflict check, get our EO team on the phone with you and kind of take it group by group, company by company to kind of revise and draft these potential letters. And again, every company, every business is different. So one size doesn't necessarily fit all. Brett, anything to add on your end?
No. We will be available to answer questions, as you said. I know we have a lot of them, and some of them are still coming in. But please reach out to either your employment attorney or your attorney, or reach out to one of us, and we can certainly help guide you. And we'll be keeping you updated with the latest as it comes out. Bernie will be reviewing more bills in the House to summarize for you. But just let us know and keep an eye on the Butzel.com website.
Yep. Thanks everybody for your time. Stay strong out there and stay healthy.
Thank you, everybody. Thank you, Bernie. Thank you, Brett. Just want to let everybody know that a copy of this presentation will be made available this afternoon on our Butzel.com webinar event page. And thank you, everyone, for attending.